You might also ask, what do you think of the consequences of not having enough earnest money?
There you go. That's what we're looking for.
And then what happens? Say that again? Stand up, have a class.
That's huge in today's market. What if they've got another offer out there that they now want, so it's higher than your offer? It's really, and I know we said preaching to the choir, it's scaring me that agents that come in and I look at their card, and these are not just fly-by-night brokerages, these are big brokerages and experienced agents. And I had someone just last week go, oh, I remember something about the contract changing. It's June. Right? I mean, that's scary. So then we're trying to fix it. I heard someone say that at one point, the broker lawyer committee had actually thought about giving the buyer the option. And that was that the option B either would go to the title company or go to the seller. But they didn't go through with that. So it's imperative that the option B, how the contract reads, and if that's the one that you're using and you should be, it's payable and delivered to the title company. So I think that if you're representing a buyer, you really need to check your checks. If you're doing a check, if they're doing a wire, it's going to get rejected if they don't have the wire set up properly. It won't even make it to us.
So if that causes the buyer or the seller to lose that deal, who's liable?
The seller to lose.
Yeah, it's up to the seller whether they want to terminate or not, because you're the default.
That's when you have that, what everyone says, a race to the title company. Once you have the default, who's going to fix it first? Is the buyer going to give us the rest of the money first? Or is the seller going to give us termination first? And if you notice on the last page of the contract where we receive the earnest money and option fee, the earnest money has the time in it. And that's why it's so important. If we were to say we're receiving the earnest money, we might get a termination email over to us. So we win.
Can I jump in with a question on this point? I attended the track commissioners hearing in November when this contract was presented for consideration, and this change had already been made. I had a prediction, and I want you to tell me if I'm right or wrong. But I'd like to ask you this question: how many of you like this change? Do any of you like this change where you can write a check and take it to the title company? You know, that's new for us as residential real estate agents. That's not new in the market at all.
No.
That's how commercial deals have been done for 20 years or longer. And I predicted that it's a change. People don't like change, but once they kind of work with it, they're going to like it. And I think what I'm hearing today is really do kind of like it. Yeah, I think it's a good deal. It's a good change. Just got to do it right.
It's easier.
Not to regress, but it's easier for y'all, especially if you're working for the buyer. You go chase down an agent or get the seller to sign it. So we've been, I tell this story. I don't know how many years ago it's been when the contract changed, 8, 9 years ago, about the survey, about you tender the survey and the title company rejects it. Then there's a check box for buyer, seller. There were so many agents that would check buyer, but they would never tender the survey or the T47. And they go, well, it doesn't matter, the buyer's going to pay it. And I argued and argued and argued for about 6 or 8 months with agents. No, you have to perform first before it does default to the buyer or seller, whatever the box is checked. And agents, I mean, I can't tell you how many times they hated the quote change. Now you don't even think about it. And I think you're going to see the same here in the option earnest as well. All right. Again, we've got little topics here to kind of fuel the fire. But, we're really kind of looking to you guys to kind of spur the direction. Yes, sir.
I got a general question about basically putting it down, putting in like a stipulation that you're allowed to do
You mean use of the property?
It's probably check, it's like 60 days.
Page 3.
So I'm wondering about like specifics about what to put in there. I got a client right now that wants to put a pool and like concession on the house. And how specific you need to be there in order to make sure that not just a pool anywhere, but a pool here and perhaps an extension anywhere, but you know, how specific it would be for that requirement. And
Well, this is talking about use. It's not saying necessarily that it's going to pass ordinance in terms of setback or building code. It's talking about use. Can this property be used for a pool? And unless there's some restricted covenant that says otherwise, you're going to be
it does not apply to setbacks or like.
That's a, no, that's a
no,
city.
it's the use is permitted. Now, you got to construct it in such a way that it complies with building code, setback lines, and whatever else other requirements that are imposed either by the city or by restricted covenants that be both.
Where that one really comes into play a lot is if someone maybe is buying a residential property and they want to convert it maybe to commercial,
Yeah.
and they might, have that caveat in there that they can.
Yeah, I've got a 60-inch water main that runs through my property. If you didn't know that, public property, that would, I wouldn't have been able to put my pool where that is, had to be away, so this, that in there, or the tiles not, or.
When you bought it, didn't you get a survey?
I bought the house, so, yeah, but I'm just saying,
The pool was in, or?
yeah, and it was just squeezed over a portion of my yard, but, if there had not been approval, you might not know that until the survey came in, and the survey would bring that to light. So
Right.
couldn't you use this paragraph for that, or is that not for that?
You have that right to object to the survey. It's already
It's
discussed
not
in
in
the
the use. Yeah.
first sentence there. That's why, second sentence, buyer must object the earlier closing date or late number of days, which I'll take a step back. That number of days is often left blank.
Blank.
And it is so important for that very reason. I really think you should always put in a number of days, but it's after you receive commitment exception documents in the survey. So you would have gotten the survey, you would have seen that easement would have lined through and you would have rejected.
Okay.
That probably couldn't have been cured, so then you would have had that.
Yes, ma'am.
Think about this, it's use, not, well, my particular site fit my use, is the use itself can be permitted. An example would be, maybe you want to run a business out of this property. Are you going to be able to run a business out of this property?
They can trouble.
It could be, or maybe, this really gets into the weeds here, but can I do a short-term rental? You know what I'm talking about there? And that's in a state of flux at the moment. You gotta go back and look at all the restricted covenants. So, it's talking about, is this use gonna be permitted? I don't know if that really helps you or not, but it's not your particular site, it's still gonna fit on the site because of the water line or a need. You can object to that as another provision of the contract.
What if it's not right? You said it was-
The number of days?
And the buyer had until the closing date
Doesn't say that. So, yeah,
to object.
object.
And then the seller has the opportunity to perhaps cure it, but they may not be able to. So if you're representing seller and you left that blank, you in essence are giving your buyer up until the closing date to object to something and get out.
Let me flip that. If you're representing the seller and you've just given that buyer a get out of jail card up to closing date, probably the one thing. Now, there are times, I've had a couple of agents in the past like to leave that blank and a couple of other spots blank because it thinks it gives them more wiggle room or latitude or ability to maybe even terminate. And my response back to them is, why would you do that? Why would you waste your time and effort all the way up to a 60-day close and your buyer then terminates in the 59th day? how'd you get paid? You know, I mean, why would you want to do that? Why wouldn't you button it up, make sure that you got those issues handled early, not on the last or 2 days before closing?
I have a question about, I'm not sure, did you get your answer? I'm confused on that. You said that if the pool was in a certain, like, let's say a buyer says, okay, I want to buy this house, but I really want the pool over here, and I don't know it can be here, would you put it in special provision? Where would you make note of that? Like, let's say that the pool could go back in that bar, but they're buying it, they really want it in a specific place.
The contract said, or which prohibit the following use. It's not permissive, it's prohibit. Is a pool prohibited to go on that lot? Well, it's not prohibited by restricted covenants. It's not prohibited more than likely by code. It may be not feasible because there's an easement going through the middle, or as I had one time, a high pressure gas transmission line going through the middle of the backyard, and buyer couldn't put a pool there. Notwithstanding the fact that on one fence it says contact Lone Star Gas before excavating. True story. I don't know if that answers your question or not. If you don't need to put in there,
Then
then
here's a remedy to it. If you got an option, the buyer needs to go down to the city and make sure that it get with planning and zoning. So that
And I think
Oh,
that
God.
you back to what Catherine touched on, where it says that it's given the sections, documents and the survey.
Yeah.
So you have that time to look at all those, and then make the judgment,
You would
whether
have
it's
to-
a closing date or even if you know your clients, well, they know their clients. Well, you don't have to tell the seller. That's not part of the contract. They have that right to review those documents. They may review the survey and see something else that bothers them, pool or no pool.
maybe there's a 30-foot setback on a 50-foot backyard, and they only got 20 feet.
And so they would object.
They would object because they can't put their pool in at 20 feet. They wanted a 40-foot pool.
if you left that blank, your buyer is going to have an opportunity to terminate the contract once it reviews the survey.
Yeah, I don't really want it, but I just, it's confusing.
A lot of people leave it blank.
Yeah, I know. But what I think, like, let's say there's two houses. And it's like, okay, I really like this house, but I buy it, the pool's over here. I think I'm just getting confused on where can we put that to protect your buyer, like you were saying.
They're protected based on the way the contract is, irregardless if that's.
Whether you put that in their pool or not.
So it could just be anything. You can just come up with a reason.
No. Not just option. Not just option. You've got the ability to terminate if you get the survey 20 days later. It doesn't have to be, and I just was making a comment to her. You got an option period, go up to the city and see what you can build in that yard.
Have your pool company come
Yeah.
out during the auction period and look at it.
But
Go to the cities that they want to live in, go and make sure what the city ordinance is on.
they're gonna,
That's
yeah,
not first we last, but go to the city, see what you gotta do. See where it's allowed, where it's not, and then go lay on the survey.
not even a bad idea on fences either.
Absolutely, so that you know what you're getting into.
Right.
We can't keep up with every city ordinance of every city around here, so we gotta make our hire someone responsible for their own. It's, going out and searching for the property, they got this, so have them do the research.
Right.
Find
So
out.
without a survey, if you get a survey, if you get an order survey, it takes 2 weeks or whatever it is. At the end of 2 weeks, it's ready for you have no restricted right to terminate.
No, that's not under the option. That's under the survey provision of the contract. You have a right to object and to terminate. If the buyer can't cure the objection, which more than likely, if the seller can't cure the objection, it's more than likely they would not be able to in this scenario. The buyer is going to have a right to terminate, not under the option, but under the title objection.
So how do you check?
How do you object? How do you object to a survey matter or? Well, I prefer a form. I'll be happy to send it over to Catherine. I think she may have it, but there is a form. We object to these items in the commitment or the survey, but then you demand that you cure. If you're unable to cure, then we're going to terminate.
You know, on a commercial transaction, we see it every now and then on residential, especially if a bigger property and somebody's got counsel. But almost on every commercial transaction, we'll get an objection letter from legal counsel for buyers. And a lot of them are just, they know it, but they just list every, rights of parties in possession. We object to that. And so we as title companies have to go back and reply to that. Again, you don't see it that much on residential, but
You do when your buyer
Yeah.
happens to be an attorney that would use commercial law.
Yeah.
They're very thorough on their personal.
right.
Yeah.
You get that. You got it. Yeah.
I feel I need to follow up on a comment I made with you a moment ago. I mean, I heard from you a moment ago. You said go check with the city. But that's not the only place you have to check with sometimes. Well, yes, you have restricted covenants as well as building code requirements, all right? Now, I'm reminded of a builder who framed his house in accordance with the building code of the city of University Park, Texas. And he said, well, it's okay with the city, so it's okay. Well, it wasn't okay according to the restricted covenants. It said you had to have a bigger setback. And so he said to himself, the city is going to trump the restricted covenant, so he wouldn't have to bring the whole out. Got sued. Had to tear down the whole thing, remove the slab. So it's not just the city you have to be concerned about, it's also the restricted covenant.
And keep in mind, a lot of times the city might have an ordinance of 25 foot, as he's saying, that restricted covenants could be 40 foot. Size of houses and zonings. It may say SF2 zoning is a 2,500 square foot minimum, but the restricted covenants could say 4,000.
And when I draft restricted covenants, I specifically put something in there that says these covenants will trump from city, county, ordinance.
And keep that in mind, that's part of your contract, that when the buyer receives the restricted covenants, exception documents, and survey, they then could object to something in it.
You could also go to the city website, county, look at the plats, the subdivision, see where all these are. Your way to survey, you do that. Get an idea of
Let me caution you, don't take on too much. If you tell your buyer, I'm going to look at the plat, I'm going to look at restricted covenants, I'm going to tell you whether you can change the stuff or not, I'm going to tell you what the setback line. You're taking on a lot of liability. Now, if you're prepared to do that, that's fine. I don't recommend it. But if you convey that message to your buyer, rely on me, I'll check all this out for you, then that's what you're going to have to do. Not a good idea.
And let me probably piggyback on that. We had a situation once in a subdivision that had restricted covenants this thick and the resale certificate. And for whatever reason, the listing agent said, I've got the restricted covenants, and gave them to the buyer's agent. The buyer's agent gave the restricted covenants to their client. Guess what? They didn't have all of them listed. They didn't have all of them. There were some other restricted covenants that were not part of what they provided.
Specifically, one that said they could not breed dogs. And guess what these buyers did for their business?
So be careful with that. Yes, ma'am.
I have a question about backup contracts. A lot of, I've seen it more times where they say, let's deposit a small amount for spending option up front with contract building. And then it becomes a first business to deposit the rest, a larger amount. And I've had agents tell me that they just kind of put that at 5A1 to deposit the additional money within a certain number of days, but we don't know how many days that's going to be. So it's technically not correct, is that correct? And where is it having to come back?
5A1 is just the delivery of earnest money?
Yeah.
Are you talking about on the contract or the backup addendum?
No, this is something. Backup is in the,
Are you using the back of the pen now?
yes, this is, using the backup is in the, but
Did you read our notes beforehand?
This is one of our talking points. Good job. Thank you. Checks in the mail.
And both parties typically agree that it's not a problem, it's smaller. I don't think that. Regardless of whether we should or shouldn't, how to handle that contract.
Yeah, I have back of the pen. Yeah, typically I put it in special provisions. If anyone has any thoughts on that, I do like the idea of using a smaller amount. And I get this question asked a lot, so I'll pose it to you. If your buyer is in a second position, when is their earnest money and option money due?
That's a question.
Only when it's one, the contract is first, right?
That's a thought. Some people think that they're gonna wait until they get notice that they're in the first position and then they'll bring it in. Other options,
Once you hand it over to the title company, put the checks.
yeah, I think that, your earnest money and option fees due when it's executed. And then now here's your follow-up question. If your buyer never becomes in the first position, the first contract closes, goes through, does your buyer get their earnest money and their option fee back?
Not the option.
Do
Somebody on
you,
board with that?
What was the answer?
Earnest money. That's
option
why
fee
you wouldn't
gone.
want to put a big option down on the backup.
Yeah, but normally the option is the right,
That option is applied when it closes.
yeah.
The cost of, I tell people that's just the cost of doing business. That was the cost of having
You
a
don't-
backup offer. That's my comment though, why I think the smaller amounts make sense though, because you are potentially going to not get back that option fee. So I say, let them put up a little $100 earnest money, maybe $10 option fee, and then put something in special provisions. As soon as you get notice that you're in the first position, buyer will put X amount and X amount option.
What is the term that they use in the contract when you are given notice of your first position? Anybody know what that term is? There are two effective dates. What's the first effective date called? Effective date. Effective date, right? So what she's saying is when you go to first position, there's a actual term for that. What is that term? Amended effective date. It's actually in the form itself. It's called an amended effective date. And so what you're gonna do, I always write something like, 3 days after the amended effective date. What's the amended effective date? That's the date when the listing agent notifies you that your contract is now in first position, meaning the amended effective date is today, whatever, okay? So that's usually what I do with septic. If you don't put it in that section with the earnest money, that's a little bit different.
So we're still having to write something in special provisions. Would you rather write it for us or?
You can put factual.
I always rather write it for you.
Yeah. Just put factual. Within 3 days of the amended effective date, fire till the contract. Yeah, that's okay. If Kathy wants to write for you and everyone wants to talk gas, great.
Well, let's kind of tap the brakes on that. James, you'd be adequate on that in the day. You're a.
You can always email something over and let me give a what I've seen from
If the other says, I'll put it in 5 days, I guess the only way to handle that is to do it again. What the amended effective date is.
I don't know how you would draft it.
Before the number of days comes around.
Oh, I see what you're saying. So they're saying, let's see, so you would be buyer should deliver additional earnest money of this amount to escrow it within, you're just guessing 20, 30 days.
amended before that 20 days comes around.
What happens if you get notice
Yeah.
prior to the
Right.
20 or 30 days? Your buyer really could be under contract at first position and not have to deliver the rest of the earnest money.
Or what Charles said.
Well, your amended effective date becomes the effective date, but if your contract calls for additional earnest money within
You
30
might not-
days.
You might not have an amended effective date yet.
Yeah, so stay away from 5A1, yeah.
So, yeah, so couldn't they listen to, couldn't we just cross that out and write it into provisions and then official? Yeah,
That's always what
Yeah.
So what if, you got your option period, buyer and seller agree that we're gonna go ahead and extend the option period for 5 more days for $100. Who gets $100? Additional option.
How do you tender? I heard title company, anybody else?
I heard lawyer's title.
Well, I like that. Unless it's at brand X, it won't do you a lot of good, but, so I heard at the title company, anybody else? Seller, I heard seller, anybody else? Going once, going twice?
This one's confusing. It's the seller. And if you read the amendment, it actually specifically says buyer has paid seller an additional option fee. So truly, that check should have been tendered when this amendment was executed. That's the thought process, why they drafted it that way.
And be careful about that because you may show up at the title company and the girl at the front desk doesn't know about an amendment or additional, and you hand it over and they take it and go to receipt it, get it out, and it's really not to the title company. It goes to the seller. But to the defense of our ladies up at the front, they might not know that. They just, if somebody walks in with option money or earnest money, we at least tell them we don't take that unless we have a contract. But we could have that contract on that property and somebody walks in with additional option. Doesn't come with the title company.
Last one, and then it rounds out of earnest money option fee. What happens if the buyer delivers the option money to the title company late or after the 3 days?
And we take it,
Receipt it.
receipt it. Do they have an option?
No.
Why not?
Not what, I'm sorry. Okay,
What they might. What about if the seller wants the $100, $200? Can they take the $100 and not give them an option period? That, before, whenever the seller or listing agent was receiving the option fee, if you went ahead and accepted it late, that was going to be used to give the buyer their ownership right to determine if they had that option period. Well, now that we're the ones receiving it, we cannot give or not give. So we're going to receipt it and we put the number of days on there. So that really adds an extra duty on you, a listing agent. When you get emailed a contract with the money in the option fee receipted, you need to check your dates. And if it were to be delivered late, you really need to bring that to your seller's attention and say to them, this was delivered late. We can accept it. Go ahead and give them the option period, or we could reject it. Now, keep in mind they're going to have some other outs, but there may be a situation, I've had it a couple times, where the listing agent says, no, we do not want to give the buyer that option period. So I think that you as the agent, I'm not saying you give the advice for them not to give that option, but I think that it is your duty to alert the seller, hey, this came late, these are our options.
and let them make the decision.
It's been said that you need to act in a reasonable amount of time. So it's very, I don't think you can sit on it and the day before closing, come back and say, haha, you don't have an option. But I think you need to answer it quickly.
You want to hit on changes to addendum, financing addendum? Anybody see any of that issue? Financing addendum, let's say you've got a financing addendum that says it's a $300,000 contract, and the buyer is gonna attempt to obtain $200,000 at 3.5%, 30-year. They've got X amount of time to do it, and then during that 40 days that they have to get, they decide that they want to go FHA, it's conventional.
We were talking about that Tuesday.
You were.
Yeah.
Did it happen to you?
Not, well, to me, not as an agent, a long time ago when I sold my parents' house.
Right,
They did
right.
that.
So, did anybody see an issue with that?
Yeah.
You did? So, we had a file once where the seller happened to be an attorney, and the buyer got a denial letter, and the denial letter said, and then we back up in the contract, said they were gonna get a 3% loan, 200,000 on a $300,000 house, and they were denied the 2.5% loan. So they tendered that they were terminating because they didn't get financing. I see a problem there? No, yes. Contract said they were gonna get 200,000 at 3%. They went and tried to obtain a loan at 2.5%.
And they've got 3%.
She said that they can't terminate based off of financing. Because they might have gotten a 3% loan, but they were trying to get a 2.5%, the contract said, that's what the contract says. And let me segue into that. Let's get into. Huh?
Jordan,
Okay,
Rick, I have a question.
sure,
If you're on this.
sure.
I had a wholesale buyer owner tell me that he didn't like the property improvement. Because it's up to 3 days before closing. They wanted to change it. What do you think?
two questions. If I'm the buyer, I probably don't like that. And get out of jail card. That's my thought, just see if I like it or not. I'm trying to like it.
So you're saying that the buyer or who wanted to,
The
Seller.
sellers.
the seller wanted
Thinks
to,
he knows everything and wants to change that to 14 days before closing. That you have to.
the
obtain
answer, the easy answer to that is that when has a lender ever been contractually obligated to a contract?
Why would a
I
buyer
mean,
change something to make it more restrictive on them?
Yeah.
No, I know, but why would a buyer agree to it?
Yeah.
The lender says, oh, that's fine. Yeah, try to address it. A whole different question.
It's not
Well,
a lender's arse.
yeah, but that's the problem is that the lender isn't obligated, they're not part of that contract. So they don't have to perform under what is deleted or not.
When y'all are representing buyers, are y'all getting property approval, specifically your appraisals in 2 weeks before closing?
Yeah.
I know, but the lender said.
Well, I'm talking about a generic, maybe not in the specific, as you're saying, that lender can perform, but the concern is that lender doesn't have to perform under the provision of that paragraph.
That would really worry, to be honest. And if your buyer was in agreement to change the number of days, if that were the case, then I would make sure that you stay on top of that lender very closely to make sure that if you're getting down to the days that y'all put in and you don't feel like the appraisal hasn't come in, they don't have insurance lined up, then you may need to do an extension in order to protect your buyer's earnest money. I think that you could potentially be putting your buyer's earnest money at risk, trying to get it done.
You know, I mean, we talk about this all the time, and that is how your lender's not that way here, but there are other lenders out there, how they lead the buyer and the agent on that no problem, we're going to be ready to close. And you don't close, and what happens? Your buyer's in default, and they may lose their earnest money. So you need to be on the aggressive side, and if you're getting close, what do? Do an amendment. Ask for an amendment. Or if you can't get an amendment, the the lender hasn't performed, that's when you need to have a conference with your buyer, right?
About whether to terminate.
Terminate,
Yeah.
whether to terminate or to hang in there. But I would urge you to work on getting an amendment. Maybe put up a little more money or something. Maybe even some non-refundable money to get the seller to allow you to extend. That's a little tough in this market, isn't it? To do that?
Non-refundable additional earnest.
Yes, non-refundable additional earnest for the consideration of, extend. Yes, sir.
So could the buyer terminate, like if you're down like a day before closing, and all of a sudden the lender says you're not going to be able to close tomorrow? But is that past like
It's only,
You used
2A?
the buyer did, they could get right between a closing
Uh-huh.
and terminate, and we have that happen often.
Right.
And then in the recent changes, I'm not gonna say it got snuck in there, but I think it was a change that maybe we didn't fully appreciate the reservations. And that is where they added in that you have to give notice 3 days before closing. So you can't get right up until the day of closing. I'll touch on you have 2A is buyer approval, and then 2B is more property approval.
which are different, right? Everybody knows that. Everybody knows that they're two different animals.
So I think, I've had multiple files that have blown up, and the lender just walks away, and it's the buyers that walk
And
there.
it's sad.
So I know that this is a new addendum, but goodness, I'm seeing it a lot, and I'm getting so many questions on it. The appraisal addendum. What are y'all's feelings about it?
Everybody's comfortable with it, I'm sure,
You
right?
understand it thoroughly?
Well, my wife does, so I'm like.
Any comments on it? Anybody want to talk about it? If y'all are good with it, we'll go on to something else.
Well, it's almost a must have right now. You know, and if they have to check number one, that's great for the appraiser, not necessarily great for the buyer. Very good.
Why would it be great for the appraiser?
Okay.
In a minute.
In a minute, it's real simple. Because of all the back and forth. In other words, we come in, I'll give you an example, we had one the other day, came in $65,000 below contract price.
Right,
And that's not unusual.
right.
They had an appraisal amendment, number one check. Okay, we pushed it through. The lender is not going to push back. If that's not there, the lender comes back because the buyer, and they're sending all these reconsideration funds for us to reconsider, and they're not comparable.
I guess my question to you is, if the appraisal is the appraisal, and I know you're in that business, why would the contract have any consequence on the appraisal? Whether
No,
box one was checked or
It's
box.
not necessarily the contract, it's us choosing to do the appraisal.
Oh, well,
Well, we hope.
no, I know what you're saying, but I'm just talking about why you would have that addendum box.
I
Would-
think
would
the
make
comment
this-
is that if the buyer is waiting, doing the full waiver, so lenders don't push back on you as hard.
Correct. And it's not one of those things, but it has nothing to do with the appraised amount. The appraised amount is the appraised amount. Okay? But what happens is you get an appraisal of $60,000 like that. I mean, everybody in the world, you know, the seller, the lender, they're
The mother-in-law.
they're burning up our phone lines.
Okay.
You know, what's going on? Why is this? Why didn't you use this? It's, you know.
Are we still seeing a lot of appraisal issues? Are y'all? No?
We do.
I understand you're in business, but I'm talking about from agents and their contracts. Are we,
You mean in getting it done?
no, in short by value short.
Oh.
things. I mean, we're hearing some more stories that they're I heard somebody $120,000 the other day, was short. I guess the takeaway from all this is, James, I know has preached it to y'all, and I'm gonna say the same thing. Well, make sure you huddle up with your buyer before you check that first one.
Oh, yeah.
Please. Please. Is that right, James?
And have them initially, what that property might be worth to the appraiser. That's what you gotta be very careful.
I would have bought our
Yeah. Right. That's exactly right. But, that sure gives you a lot of ammunition in that contract. When you're putting that contract up, and you've got that box checked.
Yeah.
But please
Realistically,
have the,
don't forget to ask for that proof of funds.
please have a conversation.
Honestly, what you shouldn't do, honestly, what that house is appraised for. And if that guy doesn't have $150,000, can't give you a proof of funds, you need to make sure you communicate that yourself. Yeah, that's an issue.
So here's one of our misfiled did literally keep me up a couple of nights, and that was that the offer was submitted with a financing addendum, a conventional loan, appraisal addendum with a full waiver, and the buyer had a pre-approval letter for an FHA loan. Okay, we get the contract. Okay, guess what? Property does not appraise, and the buyer's agent told me she goes, I didn't see it. I didn't see the FHA. We just did the offer and submitted it. I said to the buyer, did y'all ever talk about doing this full waiver? And they haven't. How many buyers just DocuSign their contract? Honestly. Really. So that was scary. And of course, I had a listing agent. What do you think the listing agent was saying to me? They lied. We didn't even accept the offer. They knew they were going FHA the whole time, which the buyer did know they were going FHA the whole time.
Or thought they were going that.
They thought they were, yeah. Well, agent did it.
Well, one of the things that I see, I've got a couple phone calls in the last couple of weeks. As agents, we were talking about earlier, taking on too much responsibility like that. And I get this all the time. Well, I'm telling my client, and I tell them all the time, you're not telling your client, you are giving your client options for them to make a decision. Okay, it's not your decision as the agent. You're providing the facts for the buyer to make a decision. Don't make the decision for them, because that's what you want to do. That's something Catherine told me a long time ago.
Let me tell you this, good point. This appraisal addendum, Trek didn't want to do it. I don't know if you're aware of that or not. They really did not like it. You remember what it was like before we had this addendum?
Take it up together.
And I would see the screwiest thing you have ever seen.
Two pages.
And
Reported.
they would say, some of these contracts would say, I will pay $10,000 more than the best offers you get. Or I will pay you $10,000 more than the appraised value. In other words, the purchase price itself was a little nebulous as to what they're going to pay. And so we saw all of these homegrown addendums. Some were, or I should say exhibits to the contract back then. Some were prepared by attorneys. They were as bad as the others. And some were really homegrown, either prepared by the agents or prepared by the parties themselves. It didn't involve. So Trek came out and said, that's for agents to do that, that's the unauthorized practice of law. And so they said, you cannot, they even had a record, you cannot make the purchase price ambiguous. And even though Trek didn't want to do that, there was such a demand in the industry that we got to do something that they felt compelled.
To try to protect the agents and the clients.
Yeah. And so, if you'll notice one thing about this, the purchase price is not all that fuzzy. It's the cash down payment that is fuzzy. Okay, it's the amount of the loan that's fuzzy, but not the purchase price. That's what Trek really was trying to get away from. I'll pay you $10,000 more than next best offer. That's That's so full of possible mischief. Anyway,
There is an agent that is somewhat doing that, says per seller's instructions. It's something along those lines.
Is it an agent that has been?
No, I haven't worked with it. I looked at their instructions.
well, if that was a complaint filed against you by Trek, they would maybe drill down on that and say, were you telling your principal that he needs to send you a letter that says that to protect yourself?
It's in all properties.
Yeah, but there's a lot of people moving in from out of state. I know we see it a lot on stuff. There's still a lot of states that use an escalating clause instead of this. And so that's probably an escalating clause that says they'll pay $10,000 above the final appraisal price. That's getting like the old time Wild West.
Yeah, and that's the way it was for several years.
Let's,
Well, anyway, that's what came up.
everybody turn to, if you don't mind, the addendum to property subject to mandatory membership and property owners association. Property owners. You know, there was a change to this form as well. Does anybody know it? What it was? Big change.
It's interesting, someone
Big change.
explained this contract so, and I thought it was right on point, that it's amazing you can make very minor changes that can truly have a large effect.
Significant.
In this contract, honestly, the changes that we did on, a lot of them are very minor, and they had a huge consequence on the parties, and this is one of them.
Anybody?
Just don't, who pays all those fees? And those fees are not disclosed really. You have to go get those fees.
Yes, ma'am. Yes, ma'am. I can tell you,
And it's not to your seller's benefit.
yeah.
I don't understand how you can get them to time to check.
Well,
The amount of those
you know, it's for the buyer, and it really hurts the seller.
Right.
So the idea that I want to make sure y'all leave with is if you're listing the property, do a little homework and understand it's real easy. How many times do we see those contracts just said $100, $150, and then, you know, they pay the other? Well, if you've got $400, $500, $600, $700, $800 HOA resale, mandatory, capital improvements, guess who gets to catch that? When you put $100 in there thinking, oh, the resale certificate's $150, buyer pays $100, seller's gonna pay $100 or maybe $50 or $100, but then they get $400 more. We're seeing a lot of gripes from sellers.
Well, a lot of sellers, if they bought the property 5, 6 years ago, it was under the old contract. And that one had buyer paying for capital improvement enhancement fees. So now, sellers remember that. So they're sitting there and they go, well, I paid it when I bought it. Why am I paying it now? And you, listing agent, you should have known that was the fee and you should have made sure the buyer paid for it and I didn't. And you've got very disgruntled sellers.
Our last package is $710.
There's a community up north that charges a percent of your sales price.
Yeah, I kiddingly say this, in our offices, we work with HOA companies all over. And when I die and come back next time, I'm gonna be in the HOA business. That's, talk about printing money. But, y'all need to be very careful with that. If you're representing the seller, when you take that listing agreement, you need to have a conversation with them and even call their HOA. Find out what some fees are. So when you get that offer and it says $100, you have some comprehensive of what it's gonna make your seller pay.
That's what the comment that came back like this chain was that, well, that's a blank, it's negotiable. That should be a negotiating point between buyer and seller. I think for those of us in the trenches, I don't really think it is. I think y'all get an offer and I see, you know, maybe $200 in there. It used to be the transfer fee, no problem. I don't think that that's a point that is countered back and forth. some of these subdivisions, y'all may need to.
I've seen that before, a couple of these subdivisions are in the field contracts, they are saying that the sell the house, they are. That's the 1%.
Yep.
We had one in the lake community 2 weeks ago, and it was, if you had already lived in that neighborhood, it's just a couple $100. But if you were a new buyer who had never lived there, it was $3,000 or $4,000. The seller.
So it gets it. You're gonna have it.
So question. I heard, I don't know this, I haven't read it, but I heard that the text legislature is putting caps on resale certificate amounts. You know anything about that?
You know, I think that legislature had discussed HOAs for the last 3 sessions
Yeah.
about how they were gonna reel them back.
Well, suppose this passed and the governor signed it. You know, I don't know.
Did you see anything? I have
No, I don't know.
Okay, we got about 5 more minutes, and we'll stay a little late, but your hour is 5 minutes. So I wanted to, we do a whole class on terminations. I heard somebody ask how to do an objection a while ago. Terminations, is that, everybody real comfortable with that? Y'all want to talk about that for a minute? Is everybody comfortable with how you terminate a contract, or when you terminate it, or if there is default? I mean, Kit and I kind of laughed about this a while ago. We were just standing outside about how we hear all kinds of different terms to a contract, expired, out of date, out of contract. And is there really such an animal?
Does anybody believe a contract is ever out of contract?
They're not gonna raise their hand.
Okay, now, that's not the way you deliver the question. Yeah, I got it.
No, there is no such thing as a transaction is out of contract, meaning as if two.
It's just gone today.
We're gonna move on to the next buyer. Doesn't work that way. A contract remains a contract until it is closed or terminated. Gotta be one or the other. You got to close it or you got to terminate. In some circumstances, the buyer can terminate. And, you know, those circumstances, that's another class, I suppose. And in some cases, the seller can terminate. But there's got to be a termination before the contract goes through. Written notice of termination. And it's not an email to the listing agent necessarily that says, oh my God, terminate. It's got to be a determination in accordance strictly with the provisions in paragraph, I think it's 21, notice, the notice paragraph. If it's not strictly in accordance with the notice paragraph, it's the same as no notice at all. So you may be sending emails back and forth to the other agent, but that might not be the proper place or means of notice.
And you're not party to the contract. So
Yeah.
truly, you can't
Yeah.
terminate.
Terminate it.
It would need to be from your, from one, from the
Exactly.
party.
We probably, besides some of the contractual misnomers of people leaving blanks and what have you, I think the termination one is probably across the board the one that has the most confusion to it. And we've even seen it multiple times where someone thinks proof it is gone, and they go contractually obligate with another buyer. Now they've got 2 contracts. So,
Well, it's got to be paragraph 21.
Everyone is to go.
you know, look, I
You
kind
can
of,
send it to additional people,
yeah,
but you have to at least send it to this person.
and I can't tell you how many times we get contracts that's left blank. If the 21 is not completed.
And that it's imperative, because then you need to have a conversation with your client, where do you want to receive notices? And don't just take it all on you, because then you're taking on that liability of having to send it on to them. And what if you're on the beach and you don't get it to them in the number of days?
Yeah, the recommended version of this is you have dialogue with your client where they want to receive notices. You know, by email, smoke signal, fax, whatever. And then underneath it, put CC and then you. Then you're in that same notice form as your client. Don't, my lands, there's some agents that are just fall on the sword that want everything to go through them, and then they'll delegate it out.
Exactly.
And that's not the best.
That is the worst approach. There's an agent, one of the most productive agents in Dallas County. And this agent insists that she be the person for notice, not even her client. She wants the notice. And I've told this agent for years, you know, what we did, I got the bunch, and she said, never had so far. And I said, why do you want to do that? She said, because I want to be in control. I want to be in control. That's a bad idea. What Baron said, is what you need to do. Notice goes to your client. The CC, that's how you need to do it. That protects yourself. And it really protects your client, because you may be out of pocket. And let me ask you, regarding termination, just slightly different. How many people think an offer just goes to? Withdraw the offer. Until an offer is withdrawn, it's still out there in the pond. You know, with a hook on it, that seller can pay.
We,
We could try something social provision.
yeah,
Or, take provision.
I just did a timeline last night or not before, and I laughed, and I'm gonna read y'all this one. And we used to see this more than we do now, but when we see it now, I'll chuckle. So special provisions has 3 notations. And the third one says, buyer request a response by 5 p.m. Central Time on 6/18/2021. That's the first sentence. Okay, so everybody's gonna adhere to that, right? We're gonna make sure that you get that back to the buyer and sign contract by then. So I just asked, what if you don't? Then it goes on to say, buyer reserves the right to revoke this offer at their sole discretion if the contract is not executed prior to that time. Why would you waste the effort to put that in?
Totally worthless.
Worthless. And why?
My favorite was what I call a deadly clause. This is a true story. It said, the offer contained this provision, special provision. The buyer requests a response by Monday, January the whatever, by 5 p.m. Buyer requests a response. It's meaningless. I have what I call the internet clause that says this offer is automatically withdrawn if not accepted by 5 o'clock p.m., whatever day, by an email to whatever. Specify where to whom this notice, this offer must be accepted.
Why would
Notice
you?
of the offer.
Why would you want to put that in there? Anybody know? Give me some.
Sit on it.
Right, but in today's market, you might want to be going to another deal, right? So you might want that. But even if you don't have that in there, what do? Even if they do want to go to another offer or another, what do, Kathy? Withdraw.
Yeah.
Just withdraw.
You must withdraw before going on to another.
Yes.
What if it's a multiple offer situation? They have 20 offers, they just one, and I work in the background, and my offer is out.
Well,
They can take
They
whatever.
get, so do you all send a withdrawal of offers to every multiple offer, like, would you just?
if the listing agent says that they're taking another offer, and it goes pending in MLS,
It doesn't go, it goes active option or whatever.
okay. No, I don't know about that. If you're told the seller, the property is no longer actively being marketed because somebody else has already accepted the offer, I don't know how to feel like cleaning that up.
We handed out the going around. Okay, make sure you put your license number on there. That's how you get your credit.
Y'all didn't have a call.
Yeah, it is. Yeah, it is. Yeah. You got the wrong one. Let me just say to you, we haven't done a CE class in a year and a half. I got nervous last night. I couldn't remember where my forms were, even if they were still live. I'm credited to give this, but anyway, we are. But I kind of forgot about with all y'all. There is a second page. You don't need to fill it out. The Trek likes to have a response form about how we did. We know we barely got by, so you don't. At least for your credit, give us the.
Aaron, I didn't, not all these people are right.
Yeah, I know. I was about to finish up. When I started a while ago, I got off on something else. I will come back. You know, I want to make sure everybody understands. You know, we're lawyers' title, and we're a fee attorney office, so we own the offices. Kent is the fee attorney of our offices. So Kent and Catherine have law degrees, and they answer your. A lot of times people don't realize Kent doesn't come out that much, but we get him out of the doldrums of. I'll leave it alone. Anyway, we get him out from time to time, and but he's very knowledgeable. Been in practice a long time, and we're excited to have him with us. Of course, Catherine. I want to introduce, make sure y'all know, Laura Rodriguez is over here. We got a new closer in our office, Emily Holtman. And I said yesterday at ALC that when Emily came on, that's about when COVID hit. I really didn't get out much to market her or y'all to be introduced to her. But she weathered the storm through COVID, and I'd like to have her. So again, we appreciate being a preferred vendor of y'all's, and call upon us anytime. We're going to stick around for a few more minutes if y'all want to continue, but your hour, your credit is up.
Once you've signed the sheet.
What's the name of the instructor?
I'll put all that up there.
Before we go, I don't know how to ask the question.
Oh boy.
Really, what's the difference between, however, this is what I do.
This sounds like it's set up for a bar.
Everyone thinks the release of earnest money and the term of the contract are one and the same. They're not. So can you explain to us why they're not and what the ramifications each are if you are the estate agent?
Yeah. Think of this as two different buckets. There's the earnest money bucket, and then there's the contractual obligation bucket. Let's just say there's a default, and you want to terminate the contract. Well, you would like to be able to terminate the contract and work it out on the earnest money at the same time. And there is a form that we have for that, the release of earnest money contract form, where all that is neatly tied up in a bow. The parties agree, they sign a document, both agreeing to terminate the contract and agreeing how the earnest money is being distributed. Okay, that's great, and that probably happens more often than not. Sometimes, however, there's contention between buyer and seller. Buyer has elected to terminate the contract for whatever reason. The seller doesn't want to release the earnest money for whatever reason. There could be multiple reasons. And so there's this disagreement. The contract might be terminated because of someone's default, but the earnest money has yet to be distributed, and there's no agreement as to how that is being distributed. When that happens, as to the earnest money, there is a provision in your contract that talks about what you do in that instance. You have a demand, you have one party makes a demand, the other party has the right demand upon, party makes a demand upon the other party and the title company for distribution of the earnest money from them. The other party has the right to make an objection to that, in which event the title company is just going to hold it until the parties either litigate it, mediate it, arbitrate it, or otherwise agree as to how ultimately that earnest money is to be distributed.
But they can fight and go through those processes with the earnest
they may not agree. And that's a risk if you're representing the seller, when the seller says you're in default because you didn't close on Monday.
For the contract.
Or the contract, and the buyer said, not my fault. The lender didn't have the docs ready until Wednesday. I'm not in default. There is no time as of the essence to close under the trade contract, and I close within a reasonable time, I'm not in default. So there may be a disagreement between whether they're in default or not. If you're the seller and you want to terminate that guy out, you better make sure you're right before you start selling that property to somebody else.
Well, wait a minute, if it was closed on Monday and it didn't close, then it proved. Did it on Tuesday?
Yeah, it poops.
It proved.
It expired.
We're out of contract.
Yeah, we're out of contract.
Let me throw one more thing in there on that.
Did that answer your question, Doug?
Yeah.
Okay, Baron has.
Look.
Everybody understands what you said. Talked about the two buckets.
Yep.
If you're a listing agent, you want to put the house on the market, you must terminate the contract. If you do not terminate the contract, you are not allowed to put it on the market. So that may put you in a really precarious position with two different contracts.
It happens.
All the time.
Yeah, so
Yeah.
just know, we're all educated, right? Work on it, unless you have the termination of contract as a listing agent, do not put the house on the market alone.
In the perfect world, you send out the release of contract that says who directs the money, where it goes, right? Everybody's happy. If you have a little disagreement on who gets it, you still can terminate, as he said. Here's what so many agents miss. Paragraph 18 of your contract says that you can demand the earnest money. So even if the other party isn't being cooperative, I urge you to demand the earnest money have your client demand the earnest money to the title company. That starts the clock. And then we send out that we received a demand notice. And per the contract, they've got 15 days in which to say, I don't agree. And if they don't, if they forget about it, or it went to the agent in Mexico or at the beach that wanted everything, all notices to come to them and not their client, on the 16th day, we're going to release the earnest money because they didn't object to the demand.
But you have to make that demand. So, for example, if you're using the TREC notice of buyer's termination or notice of seller's termination, that's terminating, that's dealing with the one bucket, but that's not addressing the second bucket, which is the earnest money. You have to give us a written notice of demand, which we haven't done.
Yeah, we have.
So that's different than the release of earnest money?
The release of earnest money form,
Yes.
where both parties sign,
But if both,
completely different.
no, though, but both parties can sign and agree to release it.
Yeah.
It's when you don't have that agreement that you want to do the demand.
But if the closing date is come and gone, and the seller says, I'm out of contract, and you say, no, that actually is not a true thing, but perhaps the buyer's in default, and we're gonna do the notice of seller's termination of contract. You send it over, and then, a couple days later, I have agents call, go, I want the buyer's earnest money. Well, you didn't demand the earnest money, you just terminated the contract.
It was amazing how many times the contract gets terminated. They don't agree on the earnest money. The agents, or they agree on the release of the earnest money. And an agent will call a week later and say, how can my client come pick up, when can they come pick up the earnest money? What?
But if you as a receiving agent, if you get a notice that the contract's being terminated, don't just sit on it. If you have an objection, y'all need to put that in writing that you object to the termination. And two, if you're the non-demanding party, meaning the seller put a demand for the earnest money and you get the notice that they have, you need to circle up with your client, or probably need to go talk to an attorney, and I'd probably tell them to object to the earnest money being released if they have it.
And there's nothing more time wasting for you than to be in an earnest money dispute. Believe me, it's gonna waste your time. There's only so far you should go with that before you tell your client, you need to go see a lawyer. Because the lawyer's right to do the job at some point. You're not.
Yeah, you're not getting paid to do it. Well, listen, we appreciate it. I didn't say Lynn one time. It's a lean-to. It's a limb.
He called it a limb.
It is.
It is a limb.
I call it LDIM. That's not what Google says.
Well,
It's a limb.
Everybody sign in to get credit with their license number.
hope y'all enjoyed it. We certainly enjoyed being here with you guys. It's fun.
If you have an evaluation, you can on your seat and I'll pick it up, or on the table, I'll pick it up. Google gives that really good